This video is my attempt to highlight an important distinction between the statutory law that requires a seller to provide a seller's disclosure notice and common law that requires a seller to disclose any latent or material defect he knows or should have known existed on the property. The seller's disclosure notice is required by statute and very specifically only applies to residential property subject to certain exemptions and provides only one remedy for failure to provide. The remedy for failure to provide the notice on or before the effective date of the contract is buyer's right to terminate the contract within 7 days of receipt for any reason. Under the statute, there are 11 situations where a seller is not required to provide the seller's disclosure notice, and if you want to see all 11, please Google Section 5.008 of the Texas Property Code. Common law, on the other hand, requires that every seller of every type of real property must disclose any latent or material defect he knows or should have known existed on the property to the buyer. Failure to disclose could subject the seller to a suit for damages incurred by buyer, and in some situations even treble damages under the Deceptive Trade Practices Act. Of course, to prevail, the buyer would have to prove that the seller failed to disclose with intent to induce buyer to purchase, and that buyer relied on that failure and was subsequently damaged. Now, understanding the distinctions between the requirements and remedies under statute versus common law, it is important to advise a client who falls within one of the 11 exemptions of the seller's disclosure notice that although the seller is exempt from having to provide the SDN, he is still required to disclose defects he knows or should have known existed on the property under common law. That disclosure can be oral or in writing, but of course it's always best to do it in writing. A seller who is exempted under the seller's disclosure notice statute can use whatever form he chooses for the disclosure. He's not bound to use the SDN. On the other hand, there is no prohibition against using that statutory form to do the common law disclosure. I hope I have made clear the importance of disclosure, and I always say, when in doubt, disclose. If you have any questions about what has been discussed in this video, please email me at tipoftheweek@allegiancetitle.com. Thank you for watching, and until next week, I hope you let any of the Allegiance Title team members be your resource for results. Thank you.